someone violates a contract with you or your firm, you are entitled to compensation. Fortunately, there are several possible remedies for contract breach. Contract breaches are remedied in a number of ways, including with compensatory damages, specified performance, rescission, and restitution. A cumulative remedies clause's goal is to ensure that the parties' rights that are clearly stated in the agreement are in addition to their rights that are stated by general law. Any special remedy that a party foresees it may require should be expressly preserved in the contract. In this presentation, we will focus on damages as it is one issue related to the case that we have chosen. So, what is damages? It is a compensation for damage due to breach of contract. Section 73 stated that when one party breaches the contract and another party suffers the consequences of such a breach, then the injured party is entitled to compensation.
Hi and Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Aina. I'm going to present the name and identification of the case that we choose, which is Hawkwat Foundry, Sung as a Firm versus Naga Tembaga Sdn Bhd. The plaintiff of this case is Hawkwat Foundry and the defendant is Naga Tembaga Sdn Bhd. The construction project is to build an office and a factory. The case starts with the application by the plaintiff to sue the defendant by claiming 356,833.55 ringgit Malaysia pursuant to a project agreement. The Code of Malaysian Law Journal that used in this case is 1999 1 MLJ 65. Thank you.
Hi, Assalamualaikum. My name is Isyani Atira binti Zaki. I want to present the next topic, which is the facts of the case. The parties involved in this case are Hawkwat Iron Foundry suing as a firm versus Naga Tembaga Sdn Bhd. The case started when the plaintiff had entered into the building contract with the defendant, whereby, in consideration of the contract price of Rn1,040,000 ringgit, the plaintiff was responsible for carrying out the construction to the defendant an office and a factory complex, which is the project that comes to the case in this incident. The construction of the project was divided into 4 phases, and the completion date was separated consequently and agreed upon by the parties involved. The contract, however, made it clear that the date for completion of the entire project was 30 November 1980. The final completion date apart, the parties also agreed that the plaintiff would pay 2,000 per day for the penalty of any delay in completing the project, and conversely, plaintiff will receive 500 per day by the defendant if the project was completed before the final completion date. Hence, the plaintiff had not been able to complete the entire project by 30 November 1980. The defendant did not resign the contract but agreed on 6 January 1981 to extend the completion date to 31 January 1981 instead. The plaintiff, however, still failed to complete the project by the extended date, and this resulted in the defendant issuing a threat to resign the contract. The threat aside, the defendant allowed the plaintiff to continue work, and on 24 September 1981, the plaintiff completed the project. The defendant claimed that since time was of the essence of the contract, the plaintiff, having delayed the project, was not entitled to the full contract amount. The defendant in the event only paid the plaintiff 750,000, and following that, the plaintiff sued for the balance payment. The defendant retorted by counterclaiming for 594,000 being ascertained liquidated damages and 618,000 being loss of interest on project investment and loss of income from investment. That's all from me. Thank you.
Hello, my name is Muhammad bin Abdullah Sani. So today I will continue to present the decision of the court. So the first issue is happen when there is a breach of contract when plaintiff failed to complete the project within the agreed completion date. So In this issue, the defendant did not resign the contract when the plaintiff failed to complete. Furthermore, the defendant even allowed plaintiff to remedy his default by permitting him to continue the work on the project. In this matter, time was no longer to be regarded as the essence of the contract. If time is of the essence and there is no rescission under Section 56 of the Act, there will be no compensation. Compensation is payable for the delay when time is not of the essence. Based on the Contract Act, Section 47, it allows the promisee to perform within a reasonable time when time is no longer of the essence of the contract. The other party may give him a notice fixing reasonable time, at the expiration of which he will treat the contract as an end. But in this case, the defendant did not give notice of its intention to give up the contract if the plaintiff failed to complete at the specified in the notice. The second issue is when the defendant counterclaim for liquidated damages and loss of income and interest on investment. So, when damages is shown but the amount cannot be proven, the court will usually award nominal damages. In this case, the trial judge has concluding that the loss had not been proved sufficiently by the defendant. Defendant only received 10 Malaysian ringgits as nominal damages for the loss of interest on the project, investment and loss of income on investment. Lastly, the third issue is when the plaintiff claimed for additional works on variation orders. The trial judge was wrong in granting the order for additional variation amount. The judgment should only be for the amount claimed and not together with the variation amount which was not claimed. The variation amount included in the amount claimed was 67,000 and the trial judge had accepted the variation amount of 62,000. The judgment sum was reduced from 356,000 to 352,000.
In conclusion, for this case can describe its sole function is to establish that the defendant has violated upon the right of the plaintiff by violating the agreement between them. For our case referring to Contract Act 1915 in Section 47, which are state about time for performance, where time is specific and no application to be made. It is shown what is a reasonable time is in each particular case, a question of fact. Next, for Section 56, show effect of failure time. In Section 65, consequence of rescission of verbal contract. And for Section 66, refer to obligation for person who has received advantage under what? Agreement or contract that becomes what? Lastly, in Section 75, which is compensation for failure to discharge obligation, resembling those created by contract. Finally, this case also refers to PAM 2018 in clause 23.1 is state about extension on time, which is contractor shall give a written notice to architect or client.
According to the hot pot and Foundry Sang S. Firm versus Naga Tembaga Sendirian Berhad, the defendant insisted that once the adjudication decision was ordered to be enforced under Section 47 of the Contract Act 1950, which allows the promise to be performed within reasonable time. However, that was a case involving the plaintiff application to sue the defendant for not wanting to pay when the project was completed. In this case, the defendant also opened a letter of summons for the plaintiff to counterclaim that they were late in completing the work as a factor of the defendant not wanting to pay. So, this case according to the Contract Act 47, 56, Section 1, Section 2 and Section 3, and also Contract Act 65, 66 and 67. For PAM 2018, Clause 23.1, that related to this case talk about the completion of works will be delayed beyond the completion date if relevant problems stated. In this case, there are three decisions. For the first decision is the plaintiff win, which contractor, the plaintiff, sued defendant, the client, because of delayed payment. Next, defendant, which client counterclaim said that contractor late completing the project from the actual date. But because the defendant cannot prove the exact value he lost, so here the plaintiff win. And the last one, the third decision, is that the plaintiff, the defendant wins the case against the plaintiff. To sum up, the petition in these three situations is an abuse of process. Courts may be arise to warn the issues of an injunction to prevent presentation. So the first is the occurrence of liquidated ascertained damages, which called LED, which have been claimed by the defendant because they have lost profit. Second, which is more complex, that involve the claimant who intends to assert claim to claim money after project completion but unable to claim money for variation order. So the judge decided that he had rejected the price of the variation order and the plaintiff could claim the money for the completion date for the completion project.